Okay, so I understand everyone is in, so we can get going. Good afternoon. My name is Ed Yohnka. I'm the Director of Communications and Public Policy for the ACLU of Illinois. And I want to thank you all for, on such short notice, being able to join us for this discussion about the Supreme Court, its decision yesterday with regards to birth control, and other issues that are implicated by that decision and some others that have been made. I am really pleased to be joined for this discussion this afternoon by my colleague, Ameri Klafeta, who's the director of the Women's and Reproductive Rights Project at the ACLU of Illinois. Ameri, thank you for joining us this afternoon.
Thank you. And thank you to everybody for joining us on short notice today.
So I just want to say before we begin, if you have a question, you can put it in the chat box and we'll be able to see it and then get to your questions as we go through. Again, we're only going to take up about 30 minutes of time for this, so we'll be as brief as possible, but we would, if you have questions, like to get to those as well. So Ameri, earlier today, the Supreme Court finally ended what was probably one of its stranger terms in the last few years in the middle of the COVID pandemic. So I wonder just generally what cases or issues have you been focused on and been looking at during the course of this term?
There have been a couple big cases that we've been watching as the term has come to a close, starting with the Amy Stevens case, which was decided a few weeks ago. That is the case of the woman who was fired from her job at a funeral home in Michigan. And the Supreme Court in that case held that federal employment discrimination laws applied to discrimination on the basis of sexual orientation and to people who are transgender. And it's a case that we followed with a lot of interest because it's a case that people in our office and on our team had worked up. So we had a great deal of interest in the case on a lot of different levels. We also, of course, are paying close attention to the June Medical Services case, which is the Supreme Court case dealing with restrictions on abortion providers in Louisiana. And in that case, the Supreme Court struck down those requirements that required abortion providers to have admitting privileges at hospitals within 30 miles of their clinics, following precedent from 2016 in what was a nearly identical case.
That was the Texas Whole Women's Health case, right?
Exactly. And, we know from 2016 until now, the composition of the Supreme Court has changed. So we watched that case with a lot of interest to see what would happen with today's court. And of course, we're pleased to see that the same result occurred and that the restrictions were struck down. And then in the last few days, we've been watching with interest a couple of cases dealing with religious restrictions. There was a case involving a tax credit to private religious schools in Montana, in which the Supreme Court said that if Montana was going to extend a tax credit to private schools, it had to extend that to religiously affiliated schools. And then yesterday, there were two decisions that also were of great interest to us. In the first one, the Supreme Court held that federal employment discrimination laws did not apply to certain employees of religious schools. They were teachers who had been fired for reasons that they challenged in court, and the Supreme Court held that because they fell under a ministerial exception, those claims could not go forward against the religious school. And then, of course, the decision regarding birth control coverage that we're here today to talk about.
Yeah. So let's dig in then to this decision yesterday in the birth control coverage case, and that's coverage under the Affordable Care Act or Obamacare, and right?
Exactly.
So what was this case about, and kind of what did the court actually end up saying about it?
So under the Affordable Care Act, one of the things that came out of the Affordable Care Act was it extended birth control coverage at no cost to people through their employer-sponsored plans. And that was really a game changer in terms of extending birth control coverage to people across the country. The Trump administration issued rules that expanded the scope of which type of employers could claim religious or moral exemptions from the law. And the Supreme Court held that under the Affordable Care Act, employers with religious or moral objections could opt out from providing coverage under the law. So that was the scope of yesterday's opinion.
So is there a test for who qualifies as someone with a religious or moral objection? Can I just claim to have one because I don't want to provide the coverage, and then I get to decide that based on my objection if I'm the employer for the employees?
Right. So this case has been billed as a case about religious freedom. And, we know that religious freedom should not be used as a tool to discriminate, and it should not be used as a weapon to encroach on other rights that people hold. And so in the case yesterday, the courts are generally very unwilling to look at when somebody asserts that they have a religious objection. Courts are very unwilling to probe further than that. Yesterday's decision is very broad reaching because even under prior rules, churches have never, an organization like a church has never been required to provide birth control coverage. Organizations like religious nonprofit institutions previously could follow an accommodation procedure. They would not have to provide the coverage, but somebody could still get birth control coverage through the insurance company. The Trump rules that the Supreme Court upheld yesterday are very broad, and they get rid of that accommodation mechanism. So a religious nonprofit, or now even a for-profit business, could just assert that they have an objection, be exempt from the law, and their employees would go without coverage.
So a couple of times you referred to these as the Trump rules, and I guess I want to just start by asking you, what do you mean by the Trump rules? Like, how is that rule process, and what part did that play in the decision itself?
So, we know that the Trump administration has followed along with a political agenda to chip away at reproductive rights. And this was really another part of that, another play from that playbook. That we've seen it. We've seen the same political agenda at work with the abortion restrictions that have happened across the country over the past year that led to the June Medical Services case going up to the Supreme Court. And there are still many cases in the pipeline following that. So the Trump administration went back and broadened rules that had been in place under the Obama administration. But we know this is part of their same scheme to try to chip away at reproductive rights. Part of the impact of these rules is that they really affect people they're going to disproportionately affect low-wage workers, and they're going to disproportionately affect people of color who are going to be left on their own to pay for their own birth control or scramble to find somewhere to get it. One of the places that people would go to get birth control, for example, is a Title X family planning clinic. And we know that the Trump administration went on the attack to try to defund those Title X family planning clinics, which in Illinois, the state stepped in to support them. But it's really an effort by the Trump administration to come at this from all sides.
So, one of the questions we've gotten from one of our participants here, you use that expression, and we always hear that if someone who has a religious or a moral objection, is there any distinction made in that under the law? Is there any way to say I have a religious versus a moral objection?
That's a good question. And, one of the things that it's hard to say, because one of the things that this Trump rule did was really tack in moral objections and use that to create an even bigger gap. So I think we'll have to see how that continues to play out. But that's definitely one way that these rules are much broader than things that we've seen before.
And the other question we've gotten from one of our participants is of course always the question when you get a Supreme Court decision as to whether or not you were surprised by the result being 7-2 as opposed to a possible 5-4 as others might have handicapped that.
At this point in 2020, I'm not surprised by anything. I do think I was a little bit surprised to see that Kagan concurred, but then when I read her concurrence reads like a pretty good roadmap. This case will go back to the district court for This case will go back to the district court for further analysis, and Justice Kagan's concurrence really gives a roadmap for the district court to look very critically at what these rules do and the authority to issue them.
Yeah. So let's turn, I'm sure a question that's on a lot of people's mind, Ameri, is, so what does this mean for Illinois? I think probably many of us remember that Illinois passed a statewide measure regarding contraceptive coverage a couple of years ago. And so then how does this ruling kind of intersect with that, interact, and what effect does it have?
So we have a good state law in Illinois that does require birth control to be covered at no cost under employer-sponsored plans. So we are very fortunate in that regard in Illinois. And I say fortunate, it's not really luck. It's because, we've sent lawmakers to Springfield who have done things like pass that law and pass the Reproductive Health Act last year. The decision from the Supreme Court is, the analysis is very specific to the authority under the Affordable Care Act for the Trump administration to have issued these rules. And so I think these are two separate requirements. One area, and the state law, the state requirement is still in place. One area where people in Illinois could be left without coverage is people who are in self-insured plans, which are often large group plans. The way that state and federal law interact together, state law cannot govern those plans, so our state birth control mandate won't apply to those. In that case, people in self-insured plans are relying on the Affordable Care Act for protection, and if their employers choose to opt out of that, those are the people who could be left without coverage.
So one of the things we can say is, I think we know from the decision that there will be people who will be left out now and will be forced to pay for birth control coverage across the country.
Yes.
And that there will also be people here in Illinois that will be affected in that way.
Exactly. And we can rely on state law for some protection, but it won't protect everybody.
I keep thinking about your references to sort of the agenda of the administration to winnow back protections and access to reproductive health care. And of course, last year, Illinois enacted the Reproductive Health Act. I think we can all remember, that moment and that sense of joy when it passed and then when the governor signed it into law. So does this ruling or others that the court has issued recently, does it affect the impact of the Reproductive Health Act at all?
So again, because the Reproductive Health Act is, that's a function of state law, and the Supreme Court's decision is specific to the Affordable Care Act. These two things should operate separately, and yesterday's decision should not impact the Reproductive Health Act. I think that it does go to a larger point, which is we can have very good protections in state law, like the Reproductive Health Act, but there is the potential for these types of religious exceptions to come in and start to erode at those rights. So even though we have very strong laws in place in Illinois, it doesn't eliminate the need for us to continue to be very vigilant about areas where there is the potential for religious exceptions to come in and swallow up the protections in the law. And that's
please.
That's a large part of what we do on the Women's and Reproductive Rights Project as well. We represent individuals who have been denied reproductive health care because of their healthcare providers' religious beliefs. The ACLU of Illinois was instrumental in getting additional protections put into the Healthcare Right of Conscience Act in Illinois a few years ago, so that when people are being denied health care because of their providers' religious beliefs, they can still get the information they need. But a large part of what we do at the ACLU is to watch out for areas where these two rights may come into conflict and ensure that reproductive health care can still remain accessible and available.
I want to pick up on that question, but one of our viewers today asked the question: is there any way to know how many people in Illinois have that kind of independent insurance where that could be affected?
That's a good question. I don't know the, I don't know the, the numbers. They're large. They often are large plans. So they may be large employers who have them. And that's, that increases the potential for a lot of people to fall into that gap. Part of what makes it difficult as well is that it's very hard for people to know if their insurance is one of those self-insured plans or if it's not, because often they use third-party administrators. So somebody might have an insurance card that looks like a Blue Cross card, but they might have a self-funded plan that doesn't come under state law. So I think it's a fair number of people. I don't know the exact number, but there are a lot of issues around it that can make it difficult for people.
Yeah. Let me just remind you all, thank you for joining us this afternoon, and feel free to, if you have a question, to just put it into the chat box, and we'll go through as many of those as we can. We're actually doing great on time, so we'll have a little time to do that. The last point you were making about the exceptions and exemptions under that are built in, and this is a really these cases that you mentioned at the beginning, with the school matter and the grants for schools, with the ministerial exception, and so I was just about to ask the question, and one of our participants has probably asked it even better than I can. Is that, how scared should we be about the expansion of the ministerial exception? And, could the exception ultimately end up swallowing the rule? So, for example, what stops an employer from claiming they have a moral objection to, just picking out an example and sort of bringing these together, retaining an employee who is transgender, so that renders the Stevens case almost moot by the time you're done with those exceptions?
I think that's a really good question, because I think there is definitely a lot of cause for concern with how we've seen these Supreme Court cases going in the area of religious liberties. Even beginning with the case involving the tax credits for religious schools in Montana. When you put all of these three cases together over the last couple of weeks, I think that it is a very valid concern that the court is going in a direction that expands the notion of religious freedom at the expense of other rights. The case of the employees at the religious school, they were teachers. At those schools, you don't even need to be Catholic to be a teacher at the school. And reading the case, it seems like it would be very easy for somebody to qualify under the ministerial exception. So I think it is definitely cause for concern when we look at the direction that the court is going with these cases.
And haven't we traditionally seen that ministerial exception being one that, for example, the minister who's actually conveying the tenets of the religion, or teaching a religion class, or even the choir director, as for example, the music may be a reflection of that's something that the courts have generally held, I guess, that those things, that the church or a religious organization does have a right to decide who they want in those positions, but not, say, the janitor.
Exactly. And when you think about somebody who's a teacher who teaches math in a school, you can see how you start to go down the road. How is that very different than the janitor? And really, but it is very, very different from somebody you really do think of in a ministerial function. Yeah.
And one more thing about the employment cases, the firing of these two teachers, as I understand it or read it, was not related to religious issues. So the question wasn't even whether there was a religious purpose, but just that the religious institution couldn't be challenged at all based on sort of anti-discrimination laws.
Exactly. I think one was fired because she had been out for breast cancer treatment, and one, I think, asserted an age discrimination claim. But in both cases, you can see how the decision has very, very broad ramifications.
So I first of all, I want to invite folks, if they want to chat in some questions. I'm coming to the end of my questions, but feel free if you have one that we want to make sure that we get to everything you're wondering about. I want to just go kind of one layer deep. Early on in our conversation, you used a phrase, using religion to discriminate. And I wonder if you can kind of pick up on that a little bit in terms of how you see what the court is now trending towards, as you describe it, and allowing, and how that fits in with this notion of using religion to discriminate.
I think the birth control case is a really good example of how this is playing out. So when you think about the decision to use birth control, that's something that's very personal. That's something that people, discuss with their physician. And it's something that they do, a decision that they make on the basis of their own religious beliefs. It's not something that should be decided by the religious beliefs of somebody's employer, but that's exactly the kind of intrusion into that very personal, private decision-making sphere that we have with the Supreme Court's decision. And that's exactly how religion is being used to chip away at these rights.
So one of the questions that actually, a couple of them that we're getting, let me take these in order. The first is, so what can activists do to support the work of the ACLU in this area, Ameri?
There are a couple different things that people can do, specifically in the area of reproductive rights. I'll say that one of the places where we could use stronger protections under Illinois law is the repeal of the parental notice requirement. And people should contact their legislators and let them know that they want to see that gone, and that they don't think that law serves a purpose and it's harmful. That's one thing. Another thing is that we do have very strong protections here under state law, and that's because people turned out and they voted and they sent legislators to Springfield who, went to Springfield to put strong protections in place for the people of Illinois and their reproductive rights. In the area of reproductive rights, the other thing to be mindful of is that the June Medical Services case was, it was a good outcome, but it really was decided on a very slender margin, and it shows just how close we are to an erosion of those rights. And cases will continue to be in the pipeline, but many people in the United States live in what is already, for all practical purposes, a post-Roe world. And they don't have a lot of the protections that we have here in Illinois. So something that people can do is contact their federal legislators and say that you want to see an end to the Hyde Amendment, for example, which prohibits spending federal funds on abortion care. And again, we're lucky that our legislators here in Illinois fought to get HB 40 passed so that in Illinois, Medicaid will pay for abortion care, but that's not the case for a lot of people in this country.
And the Hyde Amendment was just included again this week in the budget that's being proposed for the next fiscal year of the federal government. Exactly.
We're in the middle of a pandemic, and there was an opportunity to try to get that out of there. And in the middle of a pandemic, again, we see the federal government looking at ways to restrict access to healthcare when they should be looking at ways to expand it and to make things easier, especially for lower wage workers and vulnerable populations.
So one question we've been talking about this a lot in the context of employers. I wonder if I could just ask you, because the question is, does this cover universities as well? I wonder if you could just talk about that for just a moment.
Yes, it does. It also applies to universities and students who are receiving their healthcare through the universities. I should note that I don't know all the specific details, but it does apply to universities as well.
And then, by the way, I do want to say that one of the people who asked a question and then has said that they're ready for the fight to get parental notice repealed is Melinda Bush, who was the Senate sponsor of the Reproductive Health Act. So goodness knows we need more friends like Melinda Bush, everywhere we can. Somebody asked if you could just sort of briefly explain again when people in Illinois would be affected by this decision. If someone working in Illinois is employed, for example, by a company outside of the state, could that company deny birth control coverage to the employee despite our state law?
Yes, you're not going to like this answer. It's a lawyer answer, but it depends. In that case, that could potentially happen. The state law applies to plans that are issued and amended in Illinois. A plan that is across state lines may not necessarily fall under the state law and may be subject to the Affordable Care Act more generally, and then more at risk for this to happen.
Great. And then another question from a participant, and I think unless anybody gets one in under the wire here, we may make this the last one. And I just have to ask, because I think people are probably wondering this. So if we had universal health care or Medicare for all, could the court have reached the same result, or do you think its analysis may have been different?
Well, I can't speak to that, but again, we should be looking at ways to expand healthcare right now, not looking for ways to take people's healthcare away for important decisions.
We did get one more question. Do you know if Hobby Lobby still requires their employees to sign an agreement that they are pro-life and that they don't, I think, use birth control?
Oh, that's a good question. I don't know the answer to that, but that's something I'm sure that my project would love to put on their to-do list to investigate.
So let me say, as we sort of move towards closing this discussion, Ameri, what other issues are you seeing kind of in the pipeline on their way to the court in this area that people ought to be thinking about or monitoring or watching?
So I think we will continue to see attacks on abortion care across the country. And I think the June Medical Services case, while a victory was not such a resounding victory, that would foreclose those cases. So I think we can expect to see more cases, especially in that area, working their way forward. And I think, again, with the recent Supreme Court decisions and the way they're going, I think we can expect to continue to see more challenges based on religion and using religion to create exemptions from some of these protections.
Will we see an attempt to overturn Roe?
Oh, well, I'm pretty sure that's the thrust of all these cases that are still working their way to the Supreme Court.
All right, Ameri, thank you so much for making time to do this this afternoon and answering all these questions. Again, thank you all for your questions and for participating in this. We really appreciate it. I want to thank Emily Scott and Jay Bach and Luis Gomez, who I know really worked very hard to put this together on such short notice. And we appreciate all of their work in making it possible for us to do this. So thank you all very, very much.